right. Looks like we hit the buttons. We did the stuff. Looks like it's working. What's going on, guys? Happy Friday. Hope you guys are having a great week as everything connects up. It looks like we're good. Let's see. All right. Yeah, looks like we're good. Cool. So we got a couple more updates. Let's see. Let's run through that. Wonder if you guys have anything fun planned for the weekend. So, all right, as we got this up, so we got a couple things that we're going to be working on today. So, kind of 3 updates, I guess, on everything that's going on with Olson and WFG. So, first and foremost, they are still battling over discovery, and it purely appears to me like Olson is just dragging this thing out as long as he possibly can, and it makes sense in on his side of the table. That if you're still doing all of the things that you want to do, if you're still pulling people over and you're still allegedly churning business and doing all of this stuff, then why would you want to inhibit that, right? And so as long as you can draw it out and as many people as you can get pulled over, and people are coming to me almost on a every other day basis or so saying more people are kind of leaving over to GFI and some of those things. So my hope was that at least people can see these videos and kind of see what's going on. So that we'll go through that first, and then we'll kind of see both sides of the argument and what they're saying there. The next part is Olson allegedly made some inaccurate statements about Shorack, and so we'll kind of go through some of that. And then also on Wednesday, they had another meeting in person in front of the judge to go through everything in discovery. And so we'll kind of run through what we think they might have said or what might have happened in that process. So today will be a little bit lighter. I can't say that. My ginger and yeah, cool. What's up, brother? Sam, are you a ginger too? Always, we got to keep this ginger thing going, man. We're a dying breed. So anyway, nice to see you. So we'll kind of run through some of that. Actually, let's start off looking at the docket, and then you guys can kind of see where we're at a little bit. So this is the docket for the U.S. District Court. It's crazy what's happening with the lawyers now. They're filtering these guys in and out. So these are all of the lawyers on the case, if you can see this. Pretty insane. And the lawyers always win, right? Anytime this stuff happens, they're the ones that end up with all the money. So this list is absolutely insane of all of these lawyers that are on this case. Kind of nuts. And that's without everybody else being at it. So let's kind of scroll down to the bottom. We'll kind of see the updates that we had for this week. So the first one we're going to be going over is this joint discovery letter with Eric Olson, and they're going to kind of be explaining both sides of why discovery is not happening. That happened on the 21st. And then on the 22nd is the letter from Shorack, and we'll go through that as well. And these are the 2 things that they're going to be that they discussed on Wednesday. So it looks like they met here on the 22nd. It was approximately, it looks like they met at 2 different times, this one for 19 minutes and this one for 13 minutes for approximately 32 minutes to kind of talk with the judge and go through what's going on with discovery and why it's not happening. I think we all kind of know why it's not happening, but we'll go through that. And if you have questions and stuff along the way, today will be a little bit shorter, so if you have questions or things that you want to talk about, that you want to bring up, maybe things that I haven't seen yet, then feel free to throw that into the chat and we'll talk about it as well. So let's dive into this first page. So this is going to be 156 on the docket. And if you want any of this stuff, go over to locals. Thank you to all of our local supporters. You guys have been absolutely amazing. If you want all of these documents, you don't have to try and dig through that whole docket thing. I've put it all nicely on locals so you can match up what's going on with the videos, and we talk about each one of these individually, so you can do all of that. We'll talk about that in a little bit too. So, all right, so this is going to be the 2 arguments over discovery. And if you remember, way back when the court ordered, I think this was actually court's order during the 21st or May 1st. No, it was actually before that. respectfully submitted this, issues, outstanding discovery issues. Okay, so we've been in discovery, I want to say, and we'll look up the actual date too, but I want to say we've been in discovery for probably 3 months by now. Olson was supposed to have turned this stuff over within like a week, and we're now on 3 months. So it's been forever, and they're still delaying this stuff, and we'll kind of go through what some of their excuses are. But it makes sense from his side. Like, we just had a pickleball tournament this weekend, right? And we were up in the first couple rounds. Got up a couple points. Then they came back and they passed us by a couple points. And so my teammate called a timeout. And we kind of iced them, right? So sometimes the longer you can delay things, the better it is. And I think that's exactly Olson's strategy here, is just as long as he can keep this stuff going on and they don't tell him to stop raiding WFG agents, then he's just going to be able to keep doing whatever it is that he wants to do. And so it seems like he's just going to push that off. Now, we didn't get an actual update from the last time because they also met earlier in May talking about they were supposed to work on discovery there and then also see if it was going to go into arbitration. So I haven't seen anything about them actually going to arbitration. So that'll be interesting to see as well. So anyway, here's the Olson's status update. So the Olsons immediately began collecting responsive materials after the court denied the temporary restraining order and granted expedited discovery. Oh, February 22nd, if we just would have read a little bit. So discovery has been happening for 3 months now, and WFG still hasn't gotten the stuff that they've wanted. So, and they completed their production right after WFG stopped insisting on a protective order and a one-way carve-out in its favor. Instead of engaging in the fast, limited discovery allowed by the court, WFG did not collect documents, only claimed to have finished producing documents last night, used the documents that it did not produce, which are responsive to the defendant's requests in the deposition of Valle, thank you for the corrections on that, Valle unilaterally canceled deposition notice by the Olsons on dates it had cleared. Its agents have failed to produce documents referencing in their own declarations, did not properly search for documents, and produce evidence that their lawyer secretly altered. Which we'll talk about that. This is referring to Shorack, which is the next document that we'll go into. This is the lawyer responds to this. At the same time, WFG has spent substantial efforts trying to enforce requests that the court found to be overly broad and not tethered to claims or defenses in this case, seeking to expand defendants' discovery obligations, creating unnecessary disputes about privilege logs, and filing unilateral letters about the AEO designations aimed at misusing information in the very manner of the protective order seeks to foreclose that violates this court's rules and protective order. Defendants have done their best to accommodate WFG's escalating demands that have nothing to do with the reason for discovery noted by the court or planned in the PI motion. Defendants should not have to produce any further materials, and WFG and its agents should be required to reply with their outstanding obligations so that what was supposed to be an expedited process can be completed. So basically what they're saying is that they've turned over everything that they're supposed to turn over. They don't want to turn any extra stuff over, obviously. And they're complaining about that, and then also saying that WFG hasn't done their side of the discovery, which I don't think the judge actually ever ruled on. WFG just kind of conceded and said, okay, we'll give you some stuff, you give us our stuff, and then we'll comply with some of these things. So WFG's production since May 1st, the court conference, this is the one that we were just talking about, so earlier this month they met in front of the judge. The Olsons have repeatedly asked WFG for further information about its expedited production in response to discovery, propounded by March 6th. So this is what we've seen this entire time. If you remember in the very beginning when discovery got granted by the judge said, yes, Olson's, GFI, you need to turn over this information. What's been happening since then, if you remember, they would act like they didn't really understand what was being requested, and then they do a meet and confer a week later. And so then they'd meet and confer. I don't know if you've ever been in a bad relationship, but it's kind of what happens, right? It's like, hey, I don't want you to do this. You have a big blowout. Then you kind of reconcile it. and then nothing changes, and then a month goes by. And so that's kind of what keeps happening. So like, oh, well, let's meet and talk about the demands that you have, and then nothing changes, and then they request it, and then they go, oh, well, we still don't really understand what it is that you want. So let's get back together a week later. They get back together a week later, then they act like they understand, and then they draw it out another week. And so they've been doing these meet and confers over and over and over again, and they're still not turning over that information. And so now we're all the way into March, 3 months later, and WFG still doesn't have the information that Olson allegedly has gotten off of his phones. We did a video on that. It was over 100,000 text messages and emails and information that he, in the startup of GFI, that he has, and he's turned over about 12,000 documents, which basically have nothing to do with anything. So, and he's saying, well, that's fine. I've given you the discovery, and we'll talk a little about that too. So WFG would only commit to providing rolling productions completed by May 21st, refused to give any dates by which the Olsons could expect further materials, the vast majority of which was ultimately produced on May 20th. So it looks like they did actually turn over whatever documents. So WFG has produced. They've turned it over on May 22nd. To date, WFG has made 3 productions. They turned over 461 documents on the 10th. 10,647 documents on the 16th, 664 documents on the 21st, which are mainly comprised of hundreds of publicly available documents, including materials of WFG's website and social media screenshots. WFG's agents production, defendants served subpoenas to WFG agents who submitted declarations in support of WFG's failed temporary restraining order. So Olson was asking for the people who supported this temporary restraining order. So if you remember, a temporary restraining order is basically, it was to help stop Olson from going out and doing his public tour of all of the things of what was happening, and to do this big public blowout. If you remember, we did that first video back, I don't know, it must have been beginning of February or something, where he was going to come out and tell everybody what was happening. And so they did it. They tried to do a temporary restraining order that failed. So he asked for all of the WFG agents who were in support of that and submitted declarations for that. So they've apparently, I think, turned that over. Each agent has refused to provide any documents until the day of their deposition. Okay, so they haven't turned that over. They're waiting for those agents to actually be deposed so that they can give their official statements. Although these declarants are all represented by different law firms represented in WFG, that firm has been coordinating with WFG since before this litigation has filed, including by drafting the declarations. Following of months of extensive negotiation, WFG agents agreed on April 23rd to produce all non-privileged statements they have made on or after the 22nd in text, emails that refer to the Olson's GFI and the litigation. So for instance, there was one that Olson gave out that apparently Day said, which I thought was pretty fair, but Day basically said something along the lines of, hey, if you think that just signing an NDA and then you moving to GFI and doing the anchor leg strategy and recruiting your agents and churning your business over, if you think that by doing that you're not going to be involved in the lawsuit, you should probably reconsider. And Olson took that as a threat against GFI. And for me, if I was stuck in the middle, I would want somebody to give me guidance on that possible move if I was going to go, in that you, just because Olson says you can break your contract and because he says he's going to help you with litigation, doesn't mean you're going to avoid all of those issues. So you still need to be careful with it in case something was to happen outside of that. So, which doesn't seem like a threat to me. It's more just like, it'd be like if I came to you and I'm like, hey, there's police down on the freeway over there. You probably shouldn't go speeding through there. I'm not threatening you. I'm just saying, hey, you might want to watch out. There's something going on over there. And I don't know what that red line is on there. That's weird. Anyway, okay, despite efforts of the Olsons to clarify search terms and the scope of the production, the agents refused to engage. After setting deposition dates, the agents then refused to run search terms unless defendants agreed to cover all vendor costs. Okay, so it is costly to do some of this stuff. So basically, you're supposed to get a third party. They have these really interesting things where they can do as far as getting the information off of your phone, even if it's been deleted. A lot of times they can see your text messages, your phone calls, all that kind of stuff, but it's kind of costly. And so the defendants are basically saying, well, we'll do this if you're willing to cover those costs. And then they basically, the Olsons disagreed to do that. They weren't going to pay for any of this stuff. The agents provided no response. So they're basically waiting for the Olsons. If they want to pay for it, the agents are willing to come in, turn over their phones and documents, and let them download whatever it is that they want to download. But they want to do it through a third party. They just don't want to necessarily have to pay for it. At the deposition of the declarant Nathan Shorack on the 15th, he produced 34 screenshots of text messages in which all messages other than the witness's response were erased. These redactions were not identified, rather they removed messages were rendered invisible. The messages did not include any metadata and in many instances failed to produce information sufficient to show when or with whom the message was sent. At the deposition, so a deposition is when Shorack actually probably came in person or maybe over the phone, and so they're asking him questions and he's giving it's not quite the same as being on the stand, but it's kind of the same. You're giving you're swearing that the information you're giving is accurate. But anyway, so at this deposition of Shorack and his lawyer were unable to interpret the messages, which further WFG agent depositions coming up in the 22nd of McGinnis. So on the 22nd, apparently they did the deposition of McGinnis. On the 24th, that's today, their deposition of Bosley. On the 29th, they're doing their deposition of, I don't know who this guy is, Novo Cell, if you guys know who that is. On the 31st, they're doing the deposition of Thawley. On the 6th of Charlier. On the 11th of Day, June 11th. These deficiencies should be addressed. So it sounds like they want them to hurry these up. WFG's status update. WFG and the Olsons together, the parties, have previously submitted several discovery disputes to this court. At present, all discovery disputes raised by the Olsons in the docket entry 115, so we've already gone through that. If you want to see that again, you can see it on locals, have been resolved and nothing remains to be addressed by the court. This is because WFG met and conferred with the Olsons in good faith and agreed to all of the search terms that the Olsons requested, all of the custodians of the Olsons request, and the date range they requested. WFG has since completed its documents productions, having made 4 separate rolling productions, and will produce privilege logs before the close of the business day on the 21st. The same cannot be said for the Olsons. Since the May 1st hearing, the parties have continued to meet and confer on issues submitted to the court. The Olsons, however, have rejected every compromise proposed by WFG and continue to resist conducting a reasonable search for evidence which will dispose the unlawful scheme and the false sworn statements that were presented to this court. Declaration of Eric Olson, docket number 29, declared the declaration of Miss Olson, docket number 30. In fact, 1,372 of the 12,587 documents produced by the Olsons to date are merely screenshots retrieved by a vendor that they hired for the purpose of this litigation. Accordingly, each of the matters raised by WFG in this letter's motions to the court remains unresolved. And if you remember, they might get into this. These documents that they turned over were after the termination. So again, I think it's important to do this. So again, if you go to locals, you can pull up content, go into the PDFs. I think we're on page 2 now. You can pull up the timeline. So let's pull this up. This one's free to download if you want it. And I don't know what that red line is. I apologize about that. It's not on my screen. It looks like it's only on your screen. So they only turned over documents after the termination, which is up here. So January 22nd was the termination. So he's only, that 12,000 documents is after this date. Well, why is that important? This is similar to, and I'm not calling Eric a bank robber at all, but this is similar to a bank robbery, right? So you plan the bank robbery, you then, the day of the bank robbery, and then you have the day that you get caught by the police, okay? He's not turning over any of the information of the planning of raiding WFG. He's not turning any of the documents of actually raiding WFG until he got caught and terminated. And then all the documents after that. So it's like, okay, great. How is that helpful for any of this stuff? We want the planning. We want the actual execution. Once you get caught, it, like, obviously you probably weren't doing the same stuff that you were doing beforehand. So he's playing this game of, he's just not going to turn over any of those documents that actually relate to anything that WFG wants to see. But then he goes to the court and says, well, I turned over 12,000 documents. And it's like, well, yeah, but it was documents that have nothing to, like, we already caught you. So of course you were doing different stuff after that. And after you're terminated, you could still be doing things, like you going and working at GFI is very different than you being with GFI and also WFG while you're committing the alleged breaking of your contract. So he's not wanting to turn over any of the actual information. So anything from all the way back here, when they started, they're asking for stuff from October. So you can see in here on November 28th is when they were recruiting Riviera. So they're having meetings. He's simultaneously with GFI and WFG, pretending that he's not with GFI. So he's talking to people inside of WFG to recruit them over. This is where the non-solicitation comes in. This is where the non-disparagement comes in. This is where the confidential information comes in that he's targeting specific people. And if they're not willing to go, he goes underneath them and pulls those people over so that the leader has to come with them. So he's not turning over all of these documents of them going and talking to all of these people. January 2nd is when Riviera signs the firewall and joins GFI. The meetings with Bosley. The meetings with Lopez, when he prospected Day, Shorack, the what was said around the meeting with WFG, the text messages with McGinnis, what they're doing to control the propaganda on social media. The leaders' bulletins and all the stuff that they're saying about what's going on. So you could see that the anchor leg strategy was happening. These guys were still simultaneously with WFG and with GFI. So all of that information, Olson is unwilling to turn over, but once he got caught and terminated, then the 12,000 documents actually come into play. So again, he's just not complying with any of the actual court orders of turning over these documents, but he's trying to play this game of, well, I gave you 12,000 documents, it just has nothing to do with what's actually happening. So in the submissions, Olson's complained about several matters that are not properly before the court, including documents produced by several independent WFG agents who received non-party subpoenas from the Olsons. WFG does not control its agents, and each is represented by separate counsel. As such, any disputes between Olson's and those agents regarding subpoena compliance should be raised through separate letter motions pursuant to the particular rule, not put on the agenda for the upcoming hearing. Applicable date range. So the Olson's position, the parties remain at an impasse. The court should deny WFG's attempt to obtain merit discovery through expedited discovery because the discovery seeks to events concerned prior to Eric Olson's termination. Here it is. So WFG wants information. They want information of the planning of the bank robbery, the actual bank robbery, up until you got caught. What were you saying? What were you doing? And Olson is saying, well, you shouldn't have any of those documents prior to the event of the termination. It's so silly, right? It'd be like catching your spouse cheating and they turn over the documents after the divorce. Like, that doesn't help me understand what was happening beforehand. I want the text messages of when you went over there at 4 o'clock at night and what happened and all of those things. And they're like, well, I gave you the documents of after the divorce. And it's like, what, you can do whatever you want after the divorce. That doesn't matter. That's not helpful to what we're trying to figure out. So, cannot be relevant to the injunctive relief it claims to seek. Contrary to WFG's characterizations, a September 1 cutoff is not compromise. It's not a compromise. So Olson feels that it's not a compromise to give them the actual information that would justify or disprove why he did what he did and what he said and why he said it. He's saying that that's just not a compromise, that they are unwilling to give up any information that would actually incriminate himself, which, fair enough, okay? They're saying that it's overbroad date range and insists on for months, in which the court already rejected in denying its motion to compel, in which the judge denied in affirming this court. And what's interesting too is they're so good at, the judge denies something and then they just correlate it with something else. So the judge will say, no, we're not going to do a temporary restraining order. And then they go, well, the temporary restraining order was denied because of this. It's an interesting game. I mean, I guess it works though, because they've been putting this off for a long time. So, in which WFG nonetheless insists upon without compromise since the May 1 hearing, which I think is hilarious, right? So they're saying that WFG is unwilling to compromise, and their definition of compromise is not get the information that actually covers the time frames of when things happen. So this is the bank robber saying, they're not compromising with me, they're not allowing me to give them the information that I want to give them. For some reason, they want the information that involves the planning and the actual execution of the bank robbery, and so they just are unwilling to compromise with me. And I've done everything that I can to try to do what they want, but they are unwilling to compromise. It's silly, right? So WFG previously was asking for a lot broader stuff, and they allowed them to cut it down to September 1st. So, because as we know, this was going on even before that. A lot of agents have come out and said this has been happening for years. They've been talking about this. Even at least back to the last convention, they were talking about starting their own company. So September 1st is a pretty reasonable cutoff date to actually catch the person doing the actual alleged crime. And of course, he doesn't want to turn over that information. So these materials have nothing to do with any ongoing activities that WFG could possibly enjoin, are unrelated to the two reasons given by the court for expedited discovery, and it's the same date range WFG itself used. The broad search terms of Olson used, including WFG, are based on the January 22nd cutoff. So we will give you everything you want after you caught us robbing the bank. So but anything from after that, we'll tell you all that you want, so as to not capture every email Mr. Olson sent while he worked at WFG, because the term was in his signature block. So it's just way too burdensome. Every email that Eric Olson sent had WFG in his signature. So it's just way too much work for us to give you the actual information that you need. And so it's not fair to us that we should have to turn over this information because every email has it. So, which would be interesting because I've never seen Eric Olson actually associate himself with WFG. It's always Pinnacle. So, but maybe if he's securities licensed, maybe it's in there, something like that. I don't know, could be. So the Olsons have finished producing documents and should not be required to do this again. So they've already given all the documents. Why would you possibly make them do this all over again? That's just not fair, Judge. So anyway, I'm sorry. It's just funny to me. So that's Olson's position. Here's WFG's position. The Olsons have refused to produce any documents dated before January 22nd. When WFG terminated its agent agreement with Mr. Olson's. The Olsons have taken this position to conceal evidence demonstrating that Mr. and Mrs. Olson conspired with active WFG agents to sabotage its business, a scheme that continues to today, which is absolutely 100% accurate. They just caught Maboni, which is crazy because this is 4 months into GFI, according to GFI agents, so this is just a rumor, but according to people who were with GFI, Maboni's wife has been with them since the beginning. So since January, Maboni's wife has been with GFI. Maboni is showing up to WFG events, smiling at everybody, shaking their hands, acting like he's their friend, and then recruiting people behind their back over to GFI. That's exactly what was happening before, and this is continuing to happen simply because Olson is unwilling to turn over any information of the actual robbery of WFG's people. The discovery of this evidence is crucial to WFG's forthcoming motion for preliminary injunction, which seeks to enjoin the defendants and their co-conspirators from unlawful recruiting, misuse of WFG's confidential information, disparagement, and other unfair business practices. This is 100% accurate. So everything that happened, we got to think about the time of the bank robbery and what led up to it. We don't care about what happened afterwards. We want to know what led to this particular situation. This evidence will also expose the false statements made by defendants in opposing WFG's motion for temporary restraining order. For this reason, the judge ordered expedited discovery, which the Olsons have resisted throughout the case. So Eric and Sandra also made statements in front of the court, their depositions, which is supposed to be under penalty of perjury. So if they lied during those things, and now this information comes out from before January 22nd. So for instance, they ask for the temporary restraining order, they meet with the Olsons, and the Olson goes, we've never said anything bad about WFG, we have people who are willing to back us up on this, and so they don't get the temporary restraining order because they lied. Well, now discovery is supposed to go back and see if they actually lied. So if they got that information and they were lying about the depositions, then that's going to be really bad for them, which is probably why they don't want to turn over this information. In the interest of compromise, WFG proposed to limit the relevant date range for the expedited discovery to a period from September 1 to the present. So September, October, November, December. It adds basically 4 months to the production of what they're actually requesting. The Olsons rejected this compromise entirely, refusing to produce any discovery predating Mr. Olson's termination. So again, nothing of the bank robbery, just afterwards. Ignore the fact that Miss Olson herself resigned from WFG on October 4th, months before the arbitrary date selected by the Olsons. WFG requires discovery of September 1st to reveal the extent of the scheme and to use of confidential information prior to Mr. Olson's departure. The parties remain at an impasse as to the proposed date range, and WFG requests the court order production from September 1st to the present, which is entirely reasonable. We want to know what happened during the actual time. So let me see, we got some comments in here. May 7th, making the rule completely effective. The deadline at which WFG produce current employees and former employees. Yeah, that's a good one too. Thank you for bringing that up. So part of the data that they're asking for is who is with GFI. And the problem with that is that there probably are still people who are pretending to be part of GFI while their spouse, or pretending to be WFG while their spouse is with GFI, and they're still recruiting people over. So that's absolutely accurate too. Bound by the non-compete to inform that the employees is no longer valid. Yeah, and remember, it's not a non-compete, it's a non-solicitation. Very, very different. But yes, you're absolutely correct. So anyway, so the search terms, they want to add to that. They're going to talk a little bit about those. WFG's position. WFG accepted each and every search term proposed by the Olsons. So the WFG is saying that we're working with them. We're willing to give up some ground in order to find some mutual space. So for their part, the Olsons have not only refused to search for responsive documents using 7 search terms proposed by WFG, but also refused even to produce hit counts for any of these, despite previously agreeing to on March 7th. Without producing the number of hit counts returned on all the search items, the Olsons should not be heard to complain of an overdue burden when they have not produced any substantive to this position. Instead, they should be ordered to run WFG search terms, just as WFG agreed to run their search terms. So basically what they're saying is, if it's over burdensome, run the number, and if it comes out to 100,000, then okay, we'll make this less broad. But if it comes to 50 items that come up, then you can't say that it's over broad because it's not bringing up that many hits. So if a particular search term brings up 100,000, then we go, okay, let's kind of narrow this down so we can get it to something that's more reasonable. But you can't claim that it's over burdensome and then not even tell us how many hits that it's getting, because that's going to matter in your claim of being burdensome. So the Olson's positions on custodians. The Olsons have identified the relevant custodians for GFI. Mr. and Mrs. Olson have collected and produced materials for the relevant repositories, including GFI email addresses, GFI's agent portal, and the Olsons have explained Eric Carter and Matthew Welsh are independent contractors. Oh my God, this is so frustrating. Okay, so I'm sorry. So they're saying Eric Carter and Matthew Welsh are independent contractors. The reason why this is frustrating to me is because their claims previously was that Olson, Eric, and Sandra, and the people that WFG are apparently attacking and going after, are more like employees of WFG than they are independent contractors. So we have two almost identical systems, and anybody who's in WFG, they want to be considered employee. But anybody who's in GFI, they want to be considered as an independent contractor, because the amount of control that you have over somebody is very, very different. So when WFG is requesting information from GFI, they go, well, we can't do that. These people are independent contractors. We have no control over them. But then when WFG asks stuff, or when they ask stuff from the judge from WFG, they go, well, we're employees of WFG, and so they had control over us. Oh my God, I'm sorry, this is why I couldn't do this. Like the position WFG has taken with respect to its agents, independent contractors of GFI are not appropriate custodians, and as WFG concedes. That's absolutely true, that's fair. But then you can't also claim that you were an employee of WFG to kind of get, because that's what they're trying to do into that Williams case, is say, well, we were employees, so look at this Williams case, and then that way we relate to an employee for non-solicitation. So they want to play both sides of the fence. There's also no basis for WFG to expand the scope of expedition discovery at this late stage by ensuing subpoena to them. The court has not endorsed this, and WFG articulated no reason to believe Mr. Welsh has information relevant to the allegations against the Olsons. Of course Mr. Welsh would have information regarding the allegations. He's basically the one that's running everything and has been running it for the Olsons, so that he could kind of be the face. So they hired him basically to do all of this stuff, and they're trying to say that he's not going to have any relevant information to the allegations against the Olsons. He was there for all of it. He's basically been helping them run all of this stuff. He was running the original recruiting interview, recruiting BPMs, a lot of times the one that ran with all the WFG agents in it. I believe it was Mr. Welsh who ran all of those. He's been the backbone of GFI, and they're lying to the judge saying that he would have no relevant information of the forming of GFI, the recruiting of WFG agents, the solicitation of them, the disparagement. Mr. Welsh had nothing to do with any of that, apparently. So that's fascinating. Which relate to violation of the restrictive covenant between barring solicitation and the use of confidential information. Mr. Olson has not been with WFG agent for years, and it has not attempted to describe ways it thinks discovery from Mr. Carter if necessary for the PI relief. Okay, I don't know how they can with any morals make a statement like that saying that Mr. Welsh would have no relevant information about what's happening. He's just a independent third party who has no clue what's going on. He's just running the whole show. So anyway, WFG's position, after meeting and conferring on the issue of the custodians of GFI, counsel and the Olsons related to the only GFI custodians whose data they had collected were Mr. and Mrs. Olson, and that Matthew Welsh and Eric Carter are independent contractors and not subject to the control of GFI. Mr. Welsh had previously had this court that he had helped with planning the architecture. That's absolutely true. He has been the brains, if you will, and the brawn behind everything with GFI, creating the materials. He's been managing its trainings, hosting its meetings, and been generally the person in charge of training and educating GFI agents. 100% accurate. 100%. GFI has not identified its custodians despite WFG's identification of several emails of GFI's domain that likely have responsive information. So if you remember, they still don't know entirely who is in charge of GFI. Were there other people who helped contribute to this, knowing that there were going to be court costs involved into the probably hundreds of millions? Who else is involved? Who are the custodians? Who are the ones helping with this? And they're saying that GFI has still not turned over that information. GFI has only produced a limited set of documents from GFI and has failed to confirm which repositories or custodians they have searched. This limited document production without any identified custodians does not meet the requirements of the subpoena. Meanwhile, the Olsons have issued more than 8 non-party subpoenas for documents and depositions of WFG agents. WFG seeks to leave to use just 2 subpoenas. I guess that's Mr. and Mrs. Welsh and Carter. So, yeah, absolutely true. So everything about what's been happening would be known by Mr. Welsh. He's been the brains behind everything, and they don't want to turn over any of his information. Olson is saying that he would know nothing of any type of relevance that would help with this particular case. Document repositories, so getting documents. WFG, the Olsons and GFI have produced a limited set of Signal and Telegram messages without specifying which messages originate from which applications, and they have refused to produce any messages of GroupMe despite the fact that WFG has received significant evidence of the use of GroupMe. Some of these applications are self-deleting function. When meeting and conferring on this issue, counsel for Olson's revealed that Sandra no longer has GroupMe on her phone despite sending key messages to WFG agents in WFG agents GroupMe chat through the application before Eric Olson had left WFG. So again, and this is exactly right, they're pointing to them sending messages directly to WFG agents. We want to know what they said, how did they say it, were they making disparaging statements, were they making lies about WFG to get these agents to come over, and they are just basically deleting the app and saying, well, we don't have any information that we can turn over. So again, they're deleting, I don't know if you call it evidence at this point, but basically evidence so that they can't see what's going on. WFG has spoliation concerns. Spoliation means that they're tampering with the evidence. This would be the same thing if you got pulled over for drunk driving and they take your blood and then we don't know what happens to it after that. You can get that case dismissed because the evidence was spoiled. It was tainted in some way. If they don't know who handled it in every single step and what happened, so they're basically deleting the evidence and then basically saying that they don't have any. So and WFG is concerned about that. This evidence is getting spoiled, and the longer it takes for them to produce it, the more spoilage that's going to continue to happen. Order to produce the GroupMe messages to provide for declaration explaining the circumstances of the deletion. So why did you delete that? And of course they'll come up with some bogus thing of, we just don't use it anymore and we switched to Signal, so I decided to delete it. But if they're directly messaging WFG agents while simultaneously being in both companies and enticing them to come over, that's proof of the non-solicitation. That's proof possibly of the disparagement. So the Olson have previously explained to WFG they do not have relevant GroupMe messages to produce. We deleted the app. We don't have any information to turn over. GroupMe was an application used by Mr. Olson's Pinnacle Group while he was at WFG. Mr. Olson was terminated by WFG, and the Olsons do not communicate using GroupMe anymore. The members are removed from the GroupMe message thread. They no longer have access to the messages held within the thread. Thus, upon leaving WFG and Pinnacle, the Olsons do not have messages to produce. It's convenient. WFG's supposed spoliation concerns are unfounded. So it's unfounded that they have concerns that they were messaging people on GroupMe and then just deleted the application. So WFG is completely wrong in wanting to have any of that information, I guess. WFG admits that Mr. Olson's GroupMe messages were sent before Mr. Olson left WFG, before the relevant, oh my gosh, before the relevant time period for expedition and discovery, before litigating this initiated. So because it encompassed the communications leading up to the bank robbery and the actual bank robbery and the days thereafter, none of that should actually be relevant information because it was before Olson left WFG. It's so ridiculous. And WFG admits that while the Olsons no longer have access to this GroupMe message, having been terminated from WFG, WFG does not have access and already has the messages it has purported to seek. Very convenient. So they can just delete applications. Who knows when they actually deleted it, but so all of those messages that they sent, they've now deleted that evidence and just throw their hands up and say, well, it was after we deleted it, before we were terminated, and so all those messages before January 22nd of when he was terminated, those just shouldn't count anyway. So dishonest. Confidentiality designation. So WFG's counsel for WFG requests actions on these key documents. Olson's position is explained by the response to unilateral relief. They still want more information, and we'll kind of just skim through those. So this is just basically what they're asking for in this particular meeting that they had on Wednesday. So anyway, kind of gives you an idea of what's going on with that and the games that they're still continuing to play. So let's look at one more document before we wrap up today. That went a little bit longer than I was hoping for, but as you can see, they're still playing games with all of that, and they are not wanting to turn over actual relevant information to the case. So let's get into this message real quick about, let's see, how long is this? 3 pages. Okay, we should be able to get through this pretty quick. So this is going to be they were making statements, if you remember in the last document, about Shorack and his information being inaccurate and that he's not really doing what he's supposed to be doing. And the Olsons are basically using that as an excuse to why they're not turning over documents or not complying with stuff, at least as part of the argument. And so this is, Shorack's lawyer basically responding to those particular allegations. So it has come to our attention that the defendants, Eric and Sandra Olson, in document 56, which is the one that we just read, the plaintiffs regarding discovery issues pending between them have made material false and misleading statements about this law firm and about our client, Nathan Shorack. So they alleged that the lawyer was tainting the information on that side, that they were deleting evidence or changing it in the text messages and things that they have received. Shorack is a non-party witness who testified and produced documents on May 15th in response to the subpoena served by the defendants. So the defendants subpoenaed, the Olsons subpoenaed Shorack, and the Olsons are saying that they, him and the lawyer have tainted which is kind of funny as well, because they're tainting information, and then they're saying that Shorack is tainting information. So there is no issue before the court regarding Shorack's compliance with the subpoena served on him. Indeed, any enforcement proceedings that Olsons might produce must be brought under the federal law, civil procedure, and related case law in a venue where he lives and works. Defendants, however, have cast accusations of Mr. Shorack and this firm before the court. They appear to assume their baseless attacks will somehow tarnish the plaintiffs of World Financial Group Agency, that we will not respond, but given the attacks on this firm and on the client, we must do so. Defendants at page 1 of the letter, sweeping assertion that agents have failed to produce documents, did not properly search for documents, and prohibited evidence that the lawyer secretly altered. So that was the statement made by the Olsons. On page 2 of the letter, likely broad claims that each agent produced documents only on the day of the deposition. This is at best a gross exaggeration. Only Mr. Shorack has been deposed. Moreover, the letter distorts both the extended negotiations that preceded Mr. Shorack's deposition and, more tellingly, the specific documents sought from and produced by Mr. Shorack. That is, defendants accuse Mr. Shorack of an insufficient response to the subpoena and invite the court to criticize him without disclosing what the subpoena actually called for or what he produced, and discussed below his production was appropriate. Defendants also suggested that it is inexplainable that, in the face of the increasingly elaborate demands regarding the document searches, arguing that Mr. Shorack must provide any metadata associated with the documents that were created and stored electronically, we suggested that they share the burden of retaining the independent vendor with the capacity of addressing such matters. Their present argument overlook such key factors. So they asked the Olsons to come up and help with some of the costs for producing this information because it goes through a third-party vendor. First, Mr. Shorack is not a party in the dispute. He received a subpoena calling on him to provide testimony and directing him to produce documents consisting of statements he made after January 22nd on specific subjects, and also vaguely described documents related to statements that he made in the declaration of the subpoena. He was asked for, in one category, all statements you made to any current or former WFG agents, employees, or executives regarding Mr. and Mrs. Olson from January 22nd to the present date. All statements you made to any former WFG agents, employees, or executives regarding GFI. All statements you made on or after the 22nd regarding WFG's filing, serving litigation, or enforcing its contract covenants through litigation. So this is where they're trying to get people saying that they are intimidating and attacking WFG agents because they're warning them that they are subject to potential lawsuits if they break their contract. Category 4, all documents related to any statements made in your declaration concerning the above captioned action. Mr. Shorack served several written objections because the subpoena is overbroad and ambiguous, calling for documents and for unspecified time period in any way related to any statements in a multi-page document. We strongly disagree with the defendant's assertions about the meet and confer efforts. If defendants elect to pursue enforcement efforts, we can and will provide documentation of what actually occurred. In brief, we engaged in extended discussions with the defense counsel about the overbroad scope of the subpoena, drafted particular to category 4 as how Mr. Shorack could respond to it given that the subpoena was called for a search of electronic files. No agreement was reached, although defense counsel provided a proposed list of search terms that they contended could yield positive response documents. On behalf of Shorack, we offered to have an independent vendor conduct the discovery searches and retrieve potential response documents based on the discovery, based on search terms, if they agree to cost sharing given to Mr. Shorack in an individual non-party witness. So the reason why this is important is because he's not in the actual lawsuit, right? So he's kind of just acting in a way that is just supporting. He's supporting, so he shouldn't have to come up necessarily with additional costs. I guess we can argue that, but they declined to help with some of those costs. So question here becomes, are they asking for this information because it's going to help them, or are these more delay tactics and meant to punish these people who didn't necessarily have any part of it, right? Because if you could potentially see this as a punishment for Mr. Shorack for deferring and going against them. And if you remember, Olson has threatened some of these people, allegedly, like McGinnis, in saying that if they come out and speak against the NDA, that they could potentially end up in a lawsuit that Olson is going to sue them. So he's also threatening them, and so part of that threatening, part of that punishment is now making them cover the costs of these subpoenas. The reason why it's a little bit different than, let's say, Carter or Welsh or Cofield is because they were actually part of the lawsuit. So they had actual things to do with breaking their contract, whereas Shorack is just talking about his experience of what actually happened. And so now potentially you could look at it as a way of the Olsons are punishing him for coming out and speaking against them, and they want them to occur all the costs. So think from Shorack's standpoint, he didn't do anything wrong, allegedly, but yet he's going to have lawyer costs. He's going to have costs for coming out of pocket to turn over all these documents that they want. He's got to come out of pocket for making these declarations and going in and seeing the lawyer and defending himself on all this stuff. So you could see that as a punishment for him standing up against what Olson is doing. And so the more people that Olson can punish for all of this, they're going to come out of costs, thousands, maybe hundreds of thousands of dollars in defending themselves in a lawsuit that they're not in. That's a punishment for going against what Olson has done. Since they did not consider the issue to be sufficiently important and assume any of the financial burden of retaining a vendor, Mr. Shorack made the searches himself. So he didn't even Shorack seems like a stand-up guy to me, because he could have also said, well, they're unwilling to pay for it, so I'm just not going to do it. He didn't do that. Apparently, he made the searches himself, so he's taking time out of his own schedule. He's looking for the instances where he made statements about matters specific to those particular categories 1 through 3, and looking for documents referenced in his declaration. This was done under the lawyer's personal supervision. Mr. Shorack spent several hours searching for statements responding to those requests, and also located one document that was mentioned in the declaration, and therefore was responsive to the 4th question in there as well, even though it continued to be vague and broadly objectionable. The non-privileged results of Mr. Shorack's search, which yielded about 35 documents, were produced through his office. So Shorack isn't just doing this at home; he's doing it in front of the judge, in front of the lawyer. So he's taking time out. He's sitting there for hours, going through his phone, trying to find messages, turning the stuff over. At his deposition, counsel for defendants confusingly tried to suggest that the subpoena has also called for Mr. Shorack had agreed to produce other documents, as that was not accurate, and his knowledge of the consent of any discussion of the agreements with defense counsel could come only from communications with my firm. He, of course, did not agree with such suggestions. The documents that were produced by Mr. Shorack are responsive to the subpoena. They are statements made by Shorack on specific subjects after January 22nd, in which one text message dated on the 12th was mentioned in a paragraph 10 of the declaration. Mr. Shorack's statements, as well as the January 12th text message mentioned his declaration, were produced in their entirety. So he's turning over stuff even outside of the requested, of what Olson's requested. So it seems like he's being more than forthcoming with this information. He even printed them and gave it to him. Because it is beyond a layperson's capability, however, there was no production of any metadata, as could have been done if the defendants had been cooperating regardless possible retention of any e-discovery vendor. Defendants have no good faith basis for their accusations, much less of the false statements that I or others in my firm supposedly secretly deleted non-responsive matters. That is, the defendants are complaining that they did not receive matters that were not within the scope of the documents categories and to which they had no right to otherwise expect. Defendants complain, in short, that Mr. Shorack failed to comply with the subpoena, but that he did comply. So basically, they wanted additional information that they didn't request, and they're mad that they didn't get it. So anyway, so that's where we're at on that. So they were correcting that information that they were saying about Shorack in it not being factually accurate. Oh yeah. All right. So the FTC is also stating that they are not going after enforcing any non-compete agreements at the time. Interesting. Yeah. Non-competes are basically on their way out. So that's where we have a little bit of confusion, because the California Code 16600 is about non-competes. It's not about non-solicitation. similar but very different. Non-solicitation is just that you can't go back and talk to former agents and clients. Non-compete is that you can't do anything in the industry. So it's basically saying that Olson cannot talk to the 70 or 80,000 agents in WFG, but he can talk to the other 300 million people in the United States. A non-compete would be that he can't talk to anybody in the United States about anything insurance related. He cannot recruit them and he cannot make them clients. Non-competes are on their way out. They should be. It's not fair that you can't do anything in the industry. But the correlation that Olson is trying to make is that a non-solicitation of WFG agents and clients is therefore a non-compete. His statement is that he cannot do insurance business if he cannot recruit WFG agents and take WFG clients, which is entirely inaccurate. So the California 1600 only applies to non-competes, not non-solicitation, but he's trying to bridge the gap between the two, saying that a non-solicitation is basically a non-compete, which is entirely inaccurate. You have 300 million people you can talk to, just don't talk to the ones that you formerly had in WFG. And it's not even that you can't talk to them, it's outside of a 50-mile radius, and after 2 years, you can talk to anybody you want. Like Olson or Levitan at this point could go to a WFG event, stand outside the door, and recruit people to whatever he wanted to at this point because he's outside of the 2 years. Olson didn't wait for the 2 years, and he didn't wait to do it outside of the 50-mile radius, which he could have easily done both of those two and not have to do the non-disparagement and everything else. So, yep, you're absolutely right. The non-competes are basically on their way out in this country, which I think is a great thing. I don't think you should, if you leave a dentist firm, you shouldn't not be able to be a dentist anymore. You should still be able to be a dentist, just don't steal the former dentist's clients. So anyway, we're right on time. So I hope that was helpful for you guys. Don't forget to go over to Locals. I appreciate all of your guys' support over there. You can get access to all of these documents. I try to do as many of them free. The core documents cost me money, so those do cost if you want to become a member over there, but I appreciate you guys. Hope you have a fantastic weekend. Hope you have a ton of fun with your friends and family. Hope you have a great one, and I will see you all later. Thank you guys. Bye.